We have two different courts of appeals issuing an opinion on what constitutes a public charge in U.S. immigration law, doing it within a day of each other, and coming out on opposite positions. How is this possible? Stay tuned, and I'll explain. My name is William Kovatch, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. So when I started this, I thought I could do one video addressing the two court opinions and comparing them. But as I was going through the decisions and preparing the video, it was just getting too long. And I realized I was going to make a video of me talking for well over an hour. And quite frankly, I don't want to hear myself speak for an hour. I doubt you do. So I'm going to break this up into 3 videos. First, this video, where I'm going to explain the public charge rule itself and the recent changes made by the Trump administration. Then, I'm going to do 2 more videos, one each on each court decision from the 2nd and 4th Circuits. U.S. immigration law provides that before the United States Department of Homeland Security can approve of an application to immigrate to the United States or to become a permanent resident or, in the colloquial, to get a green card, that the applicant cannot be likely to become a public charge. So let's start with the statute. This is the actual law as passed by Congress. The basic structure of U.S. immigration law was passed in 1952. That's the Immigration and Nationality Act, or the INA. That basic structure has not changed since it was passed. However, from time to time, Congress amends the INA with other legislation. And the last time the INA was amended with respect to what is a public charge was back in 1996. But the whole concept of what is a public charge was enacted in the 1952 INA. In fact, public charge finds its way into U.S. immigration law as far back as 1882. Back in 1996, Congress passed legislation that set forth several factors that the government needs to consider before it concludes whether or not a person is likely to become a public charge. Also, it included a requirement that certain immigrants get a sponsor before they can immigrate to the United States. Except as otherwise provided in this chapter, aliens who are inadmissible under the following paragraphs are ineligible to receive visas and ineligible to be admitted to the United States. Public charge. In general, any alien who, in the opinion of the consular officer at the time of the application for a visa, or in the opinion of the Attorney General at the time of application for admission or adjustment of status, is likely to become a public charge, is inadmissible. Factors to be taken into account. In determining whether an alien is inadmissible under this paragraph, the consular officer or the Attorney General shall, at a minimum, consider the alien's age, health, family status, assets, resources, and financial status, and education and skills. In addition to the factors under Clause 1, the consular officer or the Attorney General may also consider any affidavit of support under Section 1183A of this title for the purposes of exclusion under this paragraph. So basically, when a prospective immigrant's application is not based on a U.S. employer offering a job, that immigrant needs to find a sponsor who will promise to support the immigrant financially over a period of time. Usually that's working for 40 quarters or 10 years. During that time, if the immigrant applies for and receives a means-tested government benefit, then the sponsor is on the hook to reimburse the government for the cost of that benefit. But while having a sponsor is necessary in order to get your green card, it's not all that you need. The government can still find that you're likely to become a public charge. The government still has to weigh all the factors that are in the statute. In 1999, the Immigration and Naturalization Service, or the INS, adopted its interpretation of what public charge should mean and how the factors should be weighed.
The INS published its guidance on March 26, 1999, in the Federal Register.
The INS defined public charge as a person who is primarily dependent on the government for subsistence, as demonstrated by either 1. The receipt of public cash assistance for income maintenance, or 2. Institutionalization for long-term care at government expense. In practice, this meant that the government was only looking at whether an alien was receiving cash benefits, as opposed to housing assistance or medical assistance. Or the government was looking at whether the alien was going to rely on Medicaid to pay for long-term institutionalized settings, such as a nursing home. The INS, by the way, was a part of the Department of Justice. It was the agency that administered the U.S. immigration law, that is, until September 11, 2001. After that, the INS was abolished, and Congress created a whole new cabinet-level department, the Department of Homeland Security. And today, the Department of Homeland Security, or the DHS, is the department that administers the U.S. immigration law. Interpretations of law made by the INS are still valid as long as the DHS has not replaced it with something new. The Trump administration was not happy with the way public charge was being defined. So, back in the summer of 2019, the Department of Homeland Security published new rules on how it was going to interpret public charge as it appeared in the statute. The big difference was over what government public assistance programs, or what benefits, DHS was going to consider when it determined whether a person was likely to become a public charge. The prior interpretation focused on cash assistance, like SSI. SSI is a cash assistance program that makes sure that a disabled person has a minimum level of income.
DHS published its new rule in the Federal Register on August 14, 2019. Since 1999, the prevailing approach to public charge inadmissibility has been dictated primarily by the May 26, 1999 Field Guidance on Deportability and Inadmissibility on Public Charge Grounds. Under that approach, public charge has been interpreted to mean a person who is primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance or income maintenance, or institutionalization for long-term care at government expense. As a consequence, an alien's reliance on receipt of non-cash benefits, such as the Supplemental Nutrition Assistance Program, SNAP, or food stamps, Medicaid, and housing vouchers and other housing subsidies are not currently considered by DHS in determining whether an alien is deemed likely at any time to become a public charge. DHS is revising its interpretation of public charge to incorporate consideration of such benefits and to better ensure that aliens subject to the public charge inadmissibility ground are self-sufficient. That is, do not depend on public resources to meet their needs, but rather rely on their own capabilities as well as the resources of family members, sponsors, and private organizations. This rule redefines the term public charge to mean an alien who receives one or more designated public benefits for more than 12 months in the aggregate within any 36-month period, such that, for instance, receipt of 2 benefits in 1 month counts as 2 months. This rule defines the term public benefit to include cash benefits for income maintenance, SNAP, most forms of Medicaid, Section 8 housing assistance under the Housing Choice Voucher Program, Section 8 project-based rental assistance, and certain other forms of subsidized housing. DHS has tailored the rule to limit its effect in certain ways, such as for active duty military members and their families and children in certain contexts.
Under the new interpretation, a public charge was going to be defined as anyone who has received certain public benefits for a period of 12 months in the aggregate over the preceding 36-month period. DHS expanded the list of what types of benefits the government was now going to consider to include things that were not cash benefits, things like medical benefits under Medicaid, which is a sort of health insurance for the needy, food stamps, and Section 8 housing assistance. By using the word in the aggregate, the administration was saying that if you received housing assistance and, say, food stamps in the same month, then that would count as 2 months of benefits. But a number of parties filed lawsuits across the country in order to prevent the Department of Homeland Security from enforcing these new rules. So, what exactly is the issue? There's a law that's called the Administrative Procedures Act, or the APA, and that sets the rules for how the executive branch can issue rules that interpret statutes passed by Congress. The APA, which is a federal statute, gave immigrants, immigrant advocate groups, and states and local governments the hook they needed to file a lawsuit in the U.S. District Courts. The U.S. District Courts are the trial-level courts in the federal system. A number of those trial courts granted relief before they could hold a full trial, and that's called a preliminary injunction. The point of the preliminary injunction is basically to keep things the way they are until the court can hold a full trial. And these injunctions were preventing the federal government from enforcing its new interpretation on a nationwide basis. And so the federal government appealed these preliminary injunctions to the next level, to the appellate court. The appellate courts are called the U.S. Courts of Appeal. The government was looking for something called a stay. A stay is basically just a court order that prevents a preliminary injunction from coming into force. As for the substance of the lawsuits themselves, there are legal rules about how the executive branch may interpret a statute passed by Congress. Now, the specific rules on how we determine whether an interpretation that's been adopted by the executive branch of a statute is legal were set forth in a case called Chevron. And the facts of Chevron are not really important or relevant to this discussion. What's important is that Chevron set out a two-step process. The first step, we look at the law itself. What was the specific language that Congress used? Was the language clear so that no interpretation was necessary? If the answer to that question is no, then we move on to step 2. And there, the question is whether this interpretation is permissible. One way to determine whether an interpretation is permissible is by looking to whether it conflicts with the legislative history. Now, let's take an example. Let's say a bill is introduced into one of the houses of Congress. That bill will get assigned to a committee, and that committee will then look over the bill and recommend whether it should pass or not. And if it recommends to pass the bill, it'll submit it to the full chamber, whether that's the House of Representatives or the Senate. With the bill, it will include a report that explains what the bill is meant to do, and sometimes will go line by line and explain why it's using certain language. Sometimes you can even look at the transcripts of committee hearings in order to determine what legislators intended when they passed a bill. And so, if an interpretation conflicts with the intent of Congress, well, then that interpretation can be struck down as being impermissible. And that, in a nutshell, is how the courts are going to analyze the new public charge rule. Now, this may be a bit oversimplified, but it's our basic framework. In our second video, we're going to talk about how the Second Circuit addressed this new interpretation. And then in our third video, we'll address the Fourth Circuit's approach. Thank you for watching. If you enjoyed this explanation, please give us a thumbs up. Let us know in the comments below if you have any questions, maybe how you feel about this rule. Also, let us know if there are other immigration decisions that you would like us to explain. Thank you.
Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.